appeal in the matter of Sintes and the London Borough of Tower Hamlets.
Yes, Mr. Hedgeman.
May it please your lordship's ladyship, I appear for the defendant, Appellant, before the court. My learned friend, Mr. Coffey, appears for the respondent, Claimant. In terms of housekeeping, if I may, we're listed for 2 days. We're at the bar agreed that I will have today and my learned friend will have tomorrow, save for perhaps 30 minutes for a reply at the closing my learned friend's submissions tomorrow.
Yes, well, we hope it might not take that long, but we'll see.
Yes.
We think it may not be necessary to refer to all 22 authorities in the bundle, although some are certainly significant.
Yeah.
And we have just had delivered to you one more, or we're about to have one more delivered to you, not because you need to deal with it in the next 5 minutes. And I remember from my time at the bar, it's always a bit tiresome when the court comes up with an authority at the last moment. It's not that it's transformative, but it may be useful. It follows on from Tyndall, but we can get to it in due course.
Well, perhaps, my lord, I can consider it over the luncheon adjournment.
Yes, yes.
And address anything arising.
Yes.
So I'm grateful for it.
Yes. Anyway, as I said, we have talked about it, and we hope it may not be necessary to take the full 2 days, but let's see how we go.
I'll begin, if I may, by taking the court through the fairly simple and straightforward accident circumstances, before then turning to the judgment and the key causes of action and basis of liability that come out of the judgment. I was then going to take the court to the statutory and regulatory context, that is the London Local Authorities Act 1990, and the key powers that arise in that act, followed by the licensing conditions that the defendant imposed on its street traders operating the market. Once I've done that, I will take the court through some of the authorities, but I appreciate Lord Justice Yip's indication that it may not be necessary to go back to some of the earlier authorities, because in the last few years at least, the Supreme Court has helpfully clarified much of the confusion that existed before 2004. What I will then do is take the court through the 3 bases on which liability was established by reason of a duty or nuisance against the defendant. As I understand it, the claimant's position is that from the judgment, the judge was really doing 3 things. One, he was finding that essentially this defendant created the source of danger that gave rise to this accident. And it will be necessary to look at exactly what creation of the source of danger means, and perhaps more importantly, what it doesn't mean. The second basis is the point about control, going back to Dorset, Yachts, and then Tyndall, because it is put by the claimant, and the judge, it's fair to say, placed a lot of weight on this, the extent of the control that the defendant operated or had, the regulatory control that it had over the market traders, is a pillar of the basis upon which a duty of care was said to have existed. And then thirdly, as I said before coming to the third point, that much of my skeleton argument is devoted to the issue of assumption of responsibility. As I understand it from a learned friend's skeleton, it's not being suggested that the judge was finding, if I can put it like this, a true assumption of responsibility in the way that the authorities understand the concept to be. It's really said that this isn't about assumption of responsibility as such, this is about control, and it is about creation of a source of danger. That's as I understand the claimant's position. And then finally we have the nuisance question, and as I will take the court to, it seems to me that there are two limbs to the nuisance question. One is nuisance as an aspect of a duty of care. In other words, this defendant owed a duty in respect of the running of the market, and if the market caused a nuisance to exist on the highway, part of the defendant's duty was to identify that nuisance and remove it. So really the first limb of the nuisance question, it doesn't go any further than negligence. It's really an aspect of the duty of care that's said to exist in negligence. The second limb of the nuisance question is a more traditional nuisance issue, in that it is essentially said that the defendant continued the nuisance that the market trader had created when they put the poles on the highway. The learned judge below used the word adopted. I suspect he was wrong about that, and we're dealing with continuing a nuisance rather than adopting it. But the question for the court is whether, in law, the defendant is capable of continuing or adopting a nuisance by a third party left on the highway. I will then go through of course it's right to say that the first ground of appeal really relates to that, and that is why we are before this court rather than a lower appellate judge. The remaining three grounds of appeal deal with a factual finding that the judge made below, that these poles had been on the highway since 2:45, defendant's accident happening at 5 o'clock. The third ground of appeal relates to the standard of care that the judge set in essentially requiring these poles to have been removed before the claimant's accident happened. And the fourth ground of appeal is really in respect of causation, which is to say that the judge, having found that the defendant should have inspected this area once between 2:45 and 6 o'clock, the accident happening at 5 o'clock can't be a cause of duty. I will be longer on the first ground of appeal.
Yes.
I don't imagine that the final three grounds are going to take me more than about half an hour across all of them. But it's very much the first ground of appeal that will occupy this court's time. As I say then, turning to the accident circumstances and the nature of the parties, the court will find at page 40 of the supplemental bundle. I dare say this is a picture the court has seen before. In fact, I think I put it in my skeleton argument.
Yes.
This is the scene that the claimant was confronted with when she passed through this part of the highway on the 19th of December 2019. It's right to say this photograph was taken, of course, after the accident. It is taken in approximately the direction of travel that the claimant was taking.
Well, after the accident, how long after?
It's not clear exactly how long, but it was on the day. It was on the evening.
Yes.
So is this looking south?
Yes, my lord, it is. It's looking.
And the police
south.
car is the police car on Whitechapel Road.
Correct.
So we can. There's the person standing at the very left of the picture.
Yes.
And we can see one of the stumps with someone standing beside it.
Yes.
Okay. And where she fell on this photograph is the projection of the poles on the left, or
The left of the bin. Yes. The claimant was walking in approximately this direction of travel. She'd actually come from a bus stop on the road, but had gone around one of the pitches, and so was walking across the scene that we see broadly from left to right. But she was approaching the bin, and as the court will see, to the left of the bin was this trolley, which had these scaffolding poles on it, and the court will clearly see there the scaffolding poles were protruding off the trolley on the ground behind the bin, and the claimant tripped on those.
Okay, and two things. You're not occupier.
No.
That's common ground.
Common ground.
And I think that'll do for the moment. Thank you.
And the pleaded claim says the poles were lying on the ground.
Yes.
So-
Perhaps more accurately, the end of the poles were on the ground.
Yes.
The trolley contained most of the poles, and my lord will see on the right of the trolley there are poles above the ground. The trolley is on a slant.
That, are you talking about just below a rather reddish patch in the
A
photograph?
reddish glow on the
Yeah.
ground of the highway.
But
yes,
she
my lord.
tripped on the other side,
She
near
tripped
to
on
the
the other
stump.
That's correct. I should say there was a suggestion at trial from a witness who didn't attend, who we will come on to later. There was a suggestion at trial that this trolley was broken because of the slant. That's not correct. We can't see the wheels of the trolley because they're obscured by the bin.
Mm.
But this is a seesaw trolley. It when it's at rest, it is leaning one side or the other. It's not. The judge did not find that the trolley was broken.
And you're not the highway authority?
No.
And is this right that the whole of the area, including areas covered by pitches, are highway?
That's correct, my lord. Yes.
Because they're the pavement, and in substance, they're the pavement on either side of that side of Whitechapel Road.
Yes.
Okay.
So this all took place on the highway.
The whole thing takes place on the highway.
Yes.
The licensing of the pitches is on the highway.
It's on the highway. Yes.
Thank you.
And just looking at this photo, perhaps I'm missing something obvious. What's the sort of light brown colouring? Look, as we look past the poles, there's something behind, as though it's fabric or something. I can't work
think,
out what
my
it
lord,
is.
that's a tree stump.
Oh goodness,
That's a tree
There's
stump.
another one
David.
towards the
It's
right.
a tree stump.
it's a tree stump.
And there's about 5 of them,
Right,
which people sit on.
right. Well, that makes sense. Right, thank you.
Because it's perhaps worth also mentioning at this stage that the defendant did not own either the trolley or the poles. They were owned by whichever market trader put them there. But this is not a case, as there is in some cases, where the defendant owns the equipment and essentially the market traders hire it. And in other cases where the defendant goes so far as to erect the stalls. But this is not one of those cases. Your Lordship may have seen things have changed since then, and Tower Hamlets has now moved in a direction in which it is providing the infrastructure needed to set up the stores. But that wasn't the position at this time.
And the trader who did own, or at any rate put there, the trolley and the poles was never identified.
Never identified, no. And if I could put it like this, of course, the trader that put the poles there would have been the obvious candidate
Yes.
for a claim. Because clearly, if anyone, no matter who they are, creates an obstruction, a public nuisance, or a danger on the highway, then that person is the person-in-law who is responsible for it. I should say, for completeness, clearly the highway authority, which in this case was TfL, they could not be responsible for it as highway authority because the danger wasn't part of the fabric of the highway to come within the terms of the statutory duty under Section 41 of the Highways Act. The question in
Presumably
this
it's common ground that if the trader had been able to be identified, he would have been, or they would have been, in breach of the standard licence conditions.
yes.
Is that common ground?
Yes, my lord.
Well, I suppose it's right to say they would have been in breach, in my submission, by the cessation of trading having not removed these items.
Yes.
There was-
And trading had ceased, presumably before 5 o'clock on a December night.
Well, it's technically the market is open 8 a.m. till 6 p.m. But as my lord has identified, and as came out in the witness evidence and some of the oral evidence, at this time of year, traders were in a habit of packing up earlier than 6 o'clock, for obvious reasons. It transpired in the evidence that they would perhaps start packing up by around 4 to 5 o'clock. So 1 to 2 hours before the market closed. Indeed, the judge below took notice of the fact that the sun set at 3:53 p.m. on this day, which broadly fits with it starting to get dark around 4 o'clock and thereafter. So that, as it were, is the lie of the land. It's the danger with which we are concerned. If I may then turn to the judgment below, which the court will find at tab 6 of the core bundle. What I intend to do, if I may, is to take the court through the key aspects of the judgment by which the defendant was saddled with the liability for the danger created by the market trader. I should say the judgment is quite long, and it does repeat itself in places, and so it can take a little unpicking, if I can put it like that, to try and distill the key basis of the decisions that the judge made as to why a duty of care existed in law.
Obviously, it was a reserved judgment. How long had the oral hearing been?
The oral hearing had been 2 days. I'll begin, if I may, on page 111 of the core bundle. The court will see it, paragraph 169 on page 111, the judge, in a section of the judgment saying decision on duty of care. The judge describes the defendant's assumption of responsibility for the existence of the market and the rules, licence conditions within which the market traders operate, and goes on in that paragraph to say that those matters envisage a high degree of control of the market traders. So it's quite clear that what is in the judge's mind as to why a duty of care was ultimately held to exist at common law was in large part based on the defendant's control, as the judge saw it, a high degree of control that it got in exercising its statutory function. We can see that again. Oh, I would, before I take the court to a different page, just highlight to the court paragraph 174 at the bottom of the page, which is perhaps where some of the confusion has arisen, because what the court will see the judge does at paragraph 174 is equate the defendant's position to that of the Home Office in Dorset Yacht, to that of the defendant local authority in Phelps and Hillingdon, and that of the defendant local authority in Barrett and Enfield. The importance at this moment in time is that Phelps and Barrett were, of course, decisions on assumptions of responsibility. In one, local authority assumed responsibility for a child that it had taken into care, and in the other, the defendant local authority had brought into existence a relationship of professional relationship in which the duty, well recognised by the common law, the duty to take reasonable care and skill was implied. In that case, an educational psychologist had been appointed by the local authority to provide an opinion on the claimant child's psychological condition and failed to diagnose dyslexia. classic cases, if I can put it like that, of a voluntary assumption of responsibility. The Dorset Yacht, as we will see, that is a case I will turn to in due course, was a case where throughout all of the judgments of the majority, it is clear that a central plank of the reasoning for imposing a duty there was the custody and control that the prison officers had over the Borstal boys when they took them to Brownsea Island. So I just underline that paragraph at the moment because it provides an insight into the judge's reasoning below, and it does show that the judge below was applying, basing the common law duty by applying those principles of voluntary assumption of responsibility and control, such as the law understands it from Dorset Yacht. On page 115, paragraphs 189 and 190, we see the judge referring to nuisance in the context of the duty of care that he was finding. And the judge says at 189 that it's no defence to say the nuisance was created by a third party, failing to abate the nuisance over which the defendant had sufficient control and of which the defendant was aware and had the power to abate. The defendant, as the claimant contends, has essentially adopted the nuisance. And at paragraph 190, the learned judge below again refers to the defendant's control over the nuisance. So the judge, in dealing with duty of care, is also considering principles of nuisance.
But this is in a section headed poles / scaffolding a public nuisance, which is 180 to 190.
Yes.
So, sorry, I may have misunderstood your submission, but he's not using the fact of nuisance as an argument here for the existence of a duty. I take the point you make about conflating Dorset Yacht and Phelps and Barrett in paragraph 174, but that's in a previous section.
Yes. Yes, I think, my lord, that's absolutely right. The judge here is dealing with the continuation of the nuisance point. I accept that. Perhaps jumped ahead to the second basis of nuisance.
Showed us 189. Right in thinking. Must be a typo in line 1. You know, must mean, in my judgment, it is not a defence to the claim to say.
Yes.
Yeah.
That must be correct. We have the imposition of the duty in negligence on page 112, paragraph 177. Perhaps this is where I should have gone before my Lord Justice Stuart-Smith's point that I was going to come to. The culmination of the judge's reasonings at paragraph 177, where he finds that the defendant was responsible for ensuring the market was managed and run in such a way that it did not create a public nuisance. Again, that's a branch of the negligence duty, to say that the defendant was required to identify and then remove within a reasonable time nuisances that it found on the highway. That's very much the reasoning from paragraph 177. The second ground, and this is the point that I jumped to, is that in public nuisance on the basis of the paragraph that I just took the court to. Paragraphs 189 and 190 on page 115. The judge then dealt with the standard of care on page 133. In a section entitled Frequency of Defendant's Duty to Inspect. And really the crux of it is paragraphs 267 to 268 at the top of page 133. The court will see at paragraph 267, the judge set out 3 time periods over which inspections he found should have been taken, carried out, and then at the end of paragraph 268 finds that the defendant should have inspected once in each of those time periods. And of course, the one that we're concerned with is the time period 2:45 to 6 o'clock. The judge then had found, I won't take the court to it now, the judge had found that the poles had been there since 2:45. That's a factual finding that goes to my second ground of appeal. The judge found breach at paragraph 272 on the page that we're on. He found that there were no inspections after 2:45, in breach of the guidance the defendant had given itself. And he dealt with causation at paragraph 283 on page 135. The court will see at paragraph 283. The judge found that the failure to abide by the frequency of inspections for obstructions that I have found was appropriate and concomitant with the duty of care caused the claimant to be.
Sorry, I missed it. Did he make a finding as to what inspections took place on the day?
The closest we get, I think, my lord, is the paragraph 272, page 133. No inspections after 2:45.
Right.
It was common ground that certainly after 4 o'clock there was no one on Whitechapel Road from the defendant.
Yes.
Because whilst on some days there was an early officer and a late officer, on other days there was no late officer attending, and the early officer would have left by 4 o'clock. There were, the court may have picked this up from the pre-reading, as it happened, on this day in question, a significant operation was being run on this market. There were a number of enforcement agencies attending, and there were more people from the defendant's markets team, if I can refer to them like that, in attendance than just the officer inspecting the market.
I wasn't quite sure I understood what they were doing. Were they raiding?
I beg your pardon, my lord?
Were they raiding or what?
A mixture of things. They were checking for all sorts of infringements, for all sorts of potential offences. Some raiding, no doubt. There were records of things that they had, enforcement notices they had issued, and so on. But by coincidence, that meant that there was an unusual presence from the defendant local authority and other agencies on the market. But that operation had finished by around 3 to 3:30. And I would just again make the point at page 134. The judge deals with the nuisance question insofar as it relates to the duty of care, at paragraph 278 and 279. And at paragraph 278, the judge found that there was a failure to conduct adequate and sufficient inspections. And then at 279, as such, the defendant was permitting the market to be run in such a way as to create a public nuisance. So, as I understand the relevance of nuisance to this case, as I say, it's in two parts. It's the aspect of it being a part of the defendant's duty. It doesn't, in that sense, take the claimant any further than the duty of care and negligence. Then there is the separate question about whether, in true nuisance, the defendant was capable of adopting or continuing the nuisance once the market trader had deposited the items there at 245 or thereabouts.
I'm not sure I understand that sentence, 279. The defendant, I know it comes from Dibble,
Yes.
that's easy. But the defendant was permitting the market to be run in such a way as to create a public nuisance on the adjacent footpath. What does that mean? That they weren't supervising sufficiently to pick up any nuisance that, or potential nuisance, or that the market was run in such a way as to create a public nuisance and they permitted that? What does that mean?
I'm not sure, my lord. I've tried to distill a nuisance insofar as I understand it to be relevant to those two components. The duty of care question, in other words, the defendant needed to identify nuisances created by third parties and then remove them. My reading of those paragraphs is it's speaking to that point.
It looks as though those two paragraphs have to be read together because
Yes.
it starts as such.
Yes, indeed, my lady. Then we come to the separate question about whether it is possible as a matter of law to continue a nuisance on the highway that's left behind.
But my lady is right, one needs to read these together, but if one reads 278 and 279, then he is, as such, means that what was meant by permitting the market to be run in such a way as to create a public nuisance was simply a failure of supervision.
Yes. Because there can only be a failure to supervise, a breach of a duty to supervise, which is an adjunct of the common law duty. I appreciate that's a rather island-hopping tour through the judgment. I don't know if it will assist the court to look at anything in further detail, but those are the only parts of the judgment that I intended to take the court to as things stand.
That's fine.
Yes, that's fine for the moment. Thank you.
In which case, if I may then turn to the statutory context and the regulatory context in which the defendant was operating, and I begin, if I may, with the Act, which the court will find at tab 1 of the authority of conduct. I'll begin on the very first page, because in my submission it's important for the court to consider the recital. And I would just invite the court to consider in particular paragraphs 1 and 3 of the recital. paragraph 1, of course, making the point that the provision of street trading as a benefit for the wider community that Parliament specifically had in mind when enacting the London Local Authorities Act 1990, and then paragraph 3 making clear that Parliament's intention was to equip the London Borough Councils with the control that was necessary for it to essentially discharge its statutory function. So control is, as is perhaps not surprising, at the heart of this series of regulations. The relevant part of the Act that we are concerned with begins on page 5 of the Authorities Fund, with part 3 entitled Street Trading. And I have highlighted there an important definition before turning to the regulations, the definition of receptacle, which I would just briefly invite the court to consider. The important point for our purposes is that poles, insofar as they represent the infrastructure of a stall that a trader pitches, those poles, those scaffolding poles, are part of a receptacle. The receptacle includes a stall.
Sorry, it may not matter. Can you follow that? Receptacle includes a stall, so the trolley might be a receptacle. What's the relevance of stall?
The relevance of stall, my lord, is that the scaffold poles upon which the claimant tripped were the poles that had formed the shell of the market trader's stall. And so when the stall was dismantled, they were placed on a trolley, and then that's how the pole came to be on the ground.
But where is it? The direct relevance is surely in section 27(7)(f), which is in page 12.
Yes.
Where the Act says that the standard conditions shall include such conditions as may be reasonable for regulating the storage of receptacles.
Yes.
And when we get to the standard conditions, we see that there are provisions made for keeping the receptacles safe.
Yes.
That's, I think, the answer to my lord's question.
Right, thank you.
Again, slightly a whistle-stop tour, so I don't want to take up too much time going through the Act, but I can just point out some of the other potentially important regulations. The first is Regulation 24 on page 6.
This isn't a regulation, this is a section.
Yes, I beg your pardon, I was quite right, it's a section to the Act.
So sorry.
Section 24 essentially is the power of the Borough Council to designate a licensed street and the process that must be followed when that is done. At section 25 on page 8, we have the process by which a potential market trader needs to apply for a street licence. And at the foot of page 8, there are certain barriers to where a street trading licence can be granted, such as to a person under the age of 17. Importantly, on page 9, subject to those barriers to a licence being granted, subsection 5 says the Borough Council shall grant an application for a street trading licence unless they consider the application ought to be refused. And then there are a number of grounds on which the council has discretion to refuse an application. So the point I just make pausing there is this is not quite as simple as a power to issue licences to trade to anybody who applies. There is a procedure that has to be followed. There are grounds to refuse, but subject to those grounds of refusal, the position is that the licence shall be granted, which is then subject to a discretion to refuse on any further grounds at subsection 6.
Including E, which brings in receptacles.
Yes. The regulation for section 27 on page 11 deals with the point about conditions. This is the section my Lord Justice Stuart-Smith came to a moment ago. Section 27(1)(b) makes clear that the Borough Council shall specify the conditions of the licence. Subsection 3 says that the Borough Council may make any regulations prescribing standard conditions which they may attach to the licence. And then subsection 7 at the bottom of the page says, without prejudice to the generality of subsection 3, the standard conditions shall include such conditions as may be reasonable. And then there's a host of matters, including, as my Lord identified a moment ago, as F, regulating storage and of receptacles of perishable goods. Section 28 deals with revocation of licences, and I would just draw Your Lordship's eye to subsection F. It can be a ground to revoke a licence where the trader has failed to make provision for the suitable and adequate storage of the receptacles used by him. And indeed over leave at G, where a licence holder has persistently failed to remove to a place of storage the receptacles used by him. On page 17, I just point out section 33. The reasons I gave earlier, not immediately relevant to this case, but it does contain a provision by which the Borough Council may sell or let or hire or otherwise provide receptacles. As I say, that was not in place at the time. Section 34 deals with offences, so a person who contravenes the conditions of street trading licence is guilty of an offence. Section 35, and this is perhaps the most important of those that the court will consider. I would just invite the court to consider section 35.
Yes.
That is the power to remove the receptacles. Essentially, given that the receptacles, including these scaffold poles, belonged to somebody else, that's the provision which makes it lawful for a local authority to remove them. And
is it common ground? It would seem to be common sense that that power extends to dismantled bits.
yes, that must be right. Those are all of the sections of the Act that I intended to take the court to. I suppose I would just make two important points. The first is, as I highlighted when we looked at the recital, is that Parliament has clearly conferred extensive powers of regulatory control. That's always been accepted, including powers of enforcement. But Parliament has not imposed a statutory duty to remove obstructions, nuisances, whatever it may be. The closest we get is the power that we've just seen in section 35 to remove the receptacle. If I may then turn to the licensing conditions, which the court will find at page 89 of the supplementary one. They start on page 88, but the first point that I was going to take the court to on page 89. The court will see on page 89 that receptacle is defined at paragraph 1.23 and stall is defined at paragraph 1.26. Following the definitions, we move into the conditions. They begin on page 90. And I would just, as it were, highlight some of them. On page 90 at paragraph 2.2, the obvious condition that a licence holder must comply with the conditions. And that if they don't, they may be guilty of an offence and or subject to appropriate enforcement.
An enforcement sanction
Yes.
is not itself. Yes, it is at 1.9. Includes but is not restricted to prosecution, licence, supervision, suspension, and so on and so forth.
Yes.
So I was just looking for the definition.
And then at paragraph 2.6 of the conditions, we've got the essential point, although it's spelled out in some detail, that the activities, the business activities of the licence holder shall comply with and be conducted in a manner that conforms with all relevant legislation. But again, the threat of enforcement action if it doesn't. At paragraph 3.1, we have the point that the licence is merely a consent to trade under the Act. And then I don't intend to refer to any other conditions until 3.13 over leaf on page 91. I would just invite the court to consider the wording of 3.13. This is a point that my own friend takes in a skeleton argument, so I intend to address it now.
Yes.
So this is the point that the trader must stay within their pitch limits. And as it says, no goods, boxes, containers, displays, waste or any other article should be placed outside the perimeter or within the immediate vicinity of the pitch limits, except during immediate restocking. What in my submission this is clearly designed to cover, and I note that it doesn't include the words receptacles and stall. It covers articles that one would find within the pitch, the items that are offered for sale, for example, the clothing rails in a cloister, whatever it may be. It's dealing with the interior of the pitch within the receptacle of the stall, essentially saying that can't stray onto the highway. The claimant's construction of this condition was essentially that it goes further and covers the situation in this case where a market trader had left the components of their stall essentially on the highway. And I say that puts a different gloss, a different construction on this clause, this condition, than it can bear, particularly because, as we shall see in a moment, the conditions in respect of receptacles and stalls are dealt with separately. They come up elsewhere. On page 93, we've got the provision, the conditions in respect of insurance, and at condition 7.1, unsurprisingly, there's the condition that licence holders are obliged to maintain insurance, including relating to third-party public liability. We find, I should say that there are all sorts of conditions in here relating to the conduct of the market traders, relating to food standards and food safety and so on. I'm not going to look at those, I'm just trying to stick to the relevant ones. Condition 11.5 on page 97 is the important one in respect of items that comprise a stall or receptacle. And I would just invite the court to read 11.5.
So the time for final clear in Whitechapel is 7 o'clock.
Yes, the market trading ceases at 6 o'clock.
Yes.
And then there is
be
time
clear
to,
by 7.
yes. This condition goes to my Lord Justice Bean's point about receptacles, because it clearly covers a stall or receptacle, the need for it to be cleared, removed to a place of storage off the public highway, and then backed by the power that the local authority has to remove such items when they are left on the market or adjacent street after the time that they should be. That essentially mirrors section 35 of the Act, as we've seen. That is the power that is specifically concerned with the holes that this case concerns. At page 99, there are some conditions in respect of stalls and receptacles. I don't intend to go through them in any detail, save as to note that the local authority clearly had powers to approve the stall or the type of stall that the market trader was setting up. And there's a duty to keep them within their pitch limits, and so on. Perhaps not necessary to look at them in any particular detail. The final set of conditions that I would just take the court to is on page 133, conditions relating to enforcement.
Well, do you place any reliance on page 103, paragraph 18?
Yes, my lord, and that is 18.1. No licence holder, registered assistant, or any other person act on behalf of the licence holder must endanger the health and safety of any other person. Dealing then finally with the enforcement section, 17.1 essentially is the statutory enforcement mechanism of conviction for an offence, dealt with in the magistrates' court. And then 17.2 says, I will just read this if I may, because this is the section that my learned friend says should be read in conjunction with 3.13 to essentially mean that the authority had a power to remove things at will. 17.2 says, where the council does not prosecute in the court any person who contravenes any of the conditions of their licence, in their licence, may be subject to one of the following penalties: warnings, notices, and then seizure of goods or other materials. Now, in my submission, clearly what 17.2 is doing is saying that, well, you can be guilty of an offence, but even if we don't prosecute you, we have these other enforcement powers. But what this section does not do in my submission is give the authority a general power, as the claimant would have it, to remove anything at will. The court will note that seizure of goods or other materials does not refer to stores or receptacles as 11.5 does that we looked at. It's a general warning that penalties can be issued instead of prosecution. It is not in my submission on any construction a general power to seize absolutely or anything when the authority identifies it. It doesn't go beyond the statute in that sense. The last document that the court will be taken to, and if I may leave this to my learned friend, because no doubt many of his submissions will be based on this document. It's at page 123 of the supplementary bundle, and helpfully the page numbers are printed at the top right of the page.
Okay.
This is the defendant's standard operating procedures or processes. It's important to put this document in context. These are the standard operating processes and procedures that the defendant would try to follow when exercising its statutory function. The importance of this document is that the judge used it to set the standard of care that he did. This is the document that sets out the inspection intervals that officers would try to follow. But as I mentioned earlier, it was the case and accepted by the judge below that the defendant's market officers would not follow this process as gospel. There would be days where they didn't inspect all day long. My submission, of course, is going to be that that's entirely their prerogative. It's up to them how they discharge their statutory functions. But the important point for present purposes is that the learned judge below elevated this document from a document setting out the defendant's processes for how it chose to exercise its function, its statutory function, into the basis upon which it owed a duty of care at common law and the standard of care required by that duty. Those are all of the key documents that I intended to take the court through. With court leave, I'll move to address ground one. Ground one is essentially that the judge was wrong to find a duty of care and wrong to find the defendant liable in nuisance. I will begin by a brief summary of the law as it has changed until more recent years of clarification about the interplay between statutory powers, duties, discretion, statutory functions, and private duties. I don't intend to spend very long on that, before then moving into some of the authorities in more recent years that make very clear that we are looking solely here for whether the defendant stepped into the common law arena. In other words, whether the defendant, in exercising its statutory function, entered into a position in which the common law recognises a private duty of care. That's the that's the crucial point. The period of confusion that existed from Annes and Merton up until Stoven and Gorringe, as we'll come to, was really in respect of the suggestion that an individual could be able to sue for breach of a statutory duty or a failure of discretion to choose to exercise a power, whatever it may be. And the court will no doubt be familiar with the cases, which I won't turn to, which gave rise to the suggestion that there could be a common law duty where, for example, the local authority was Wednesbury unreasonable, or whether it was irrational. It was irrational not to exercise its power, whether it had exceeded the ambit of the discretion under the Act. It had exceeded the ambit of the discretion that had been given a matter of statute or regulation. That gave rise to distinctions, often arbitrary distinctions, between policy failures and operational failures, and in turn questions of justiciability, whether the courts could even look into whether there had been a failure of a policy at a policy level. The important point for our purposes is that essentially we can park that period of confusion, because this is not a case where it is alleged that the defendant is guilty of a breach of statutory duty or an error of discretion in not exercising its powers. The important point is that the common law has always recognised, before the detour from Annes and Merton came into existence, throughout the period of that detour where there was a real focus on whether there could be liability for breach of statutory duty, and of course post that detour, the position has always been that if a statutory body enters the arena of the common law, does something that the common law identifies as a situation that would give rise to a private law duty, then those claims have been and are permissible. As I say, that is now more straightforward, because in recent years, as we shall see, the courts have done away with the distraction of whether there could be liability for breach of statutory duty, and has underscored the point that what the court is looking for is a situation in which a common law duty of care is recognised by the courts of common law. If it assists, I was going to begin with the decision in Gorringe and Calderdale.
Yes.
2004, 1 Weekly Law Reports, 1057, which the court will find at tab 9 of the Authority Fund of Volume 1. I dare say the facts of Gorringe are well known to the court. This is a case where Mrs. Gorringe was approaching in her car 50 miles an hour into a sharp crest on a road, and she didn't see a bus coming in the opposite direction, skidded into the bus, and a collision occurred. Mrs. Gorringe's case for a contribution from the local authority was that they had a power, if they chose to exercise it, to paint the word slow before the crest. They didn't do that. There was no such painting on the ground, and essentially Mrs. Gorringe said that there was a duty to do that, a parallel common law duty for the Borough Council to have done that. Now, technically, Gorringe is concerned with that question, that the statutory duty to take measures to improve road safety is not actionable. and so on that basis her claim failed. But the important comments, and the ones that I'll take the court to, are those of Lord Hoffman in his speech, because they deal with situations in which the local authority, in exercising its powers or discharging its statutory functions, does cross into that territory and does enter into the common law arena, if I can put it like that. I'll take the court, if I may, to page 272 of the authority bundle. To paragraph 13 of Lord Hoffman's speech. I've highlighted it in the margin, but the point there that Lord Hoffman is making is that an individual who suffered damage because of some positive act which the authority has done to make the highway more dangerous could sue for negligence or public nuisance in the same way as he could sue anyone else. So Lord Hoffman there is referring to the common law duty that has always existed where someone, whoever they are, creates a danger on the highway or creates a public nuisance on the highway. Lord Hoffman returns to the point on page 278, paragraph number 38. I would just invite the court to read paragraphs 38 to 39 over leaf.
Just 38, or do you want to read 39 as well?
39 as well, please, my lord.
Yes.
Lord Hoffman having found, of course, that Mrs. Gorringe's claim failed because there could be no claim for breach of statutory duty, essentially. Lord Hoffman then went on to give examples, and we see these examples distilled out in more recent authorities, of situations, different situations to that concerning Mrs. Gorringe, where the public authority has done an act or entered a relationship or undertaken a responsibility which the common law court recognises as establishing a duty of care. And those common law duties are essentially unaffected by the ratio on breach of a statutory duty, because those common law duties, of course, exist independently of the statutory context. So this was the start, really, of the clarity, the reminder that these common law duties have always existed, and of course will continue to exist. It also, because it's not particularly relevant, I'm not going to take the court through it, but it also slams the door shut, as has been said in more recent cases, on any suggestion that a common law duty can arise for errors of discretion or failures to exercise statutory powers or duties based on grounds of irrationality, for example. The important point from paragraph 38 are those categories of case that Lord Hoffman identifies as those which will give rise to a common law duty, done acts, positive acts, entered into relationships or undertaken responsibilities which give rise to a common law duty of care. And the position that we are in now, essentially, is that unless a litigant, a claimant, can fit their case into those categories as the law understands them, there can be no common law claim. That is the position that is made clear. If I could take the court, please, to tab 11 in volume 2 of the authority bundle.
If tab 11 is X, it's in volume 1 of mine.
And
Apologies.
That's right.
Of course, I guess for
It's
some
the
reason
same, it's the same case.
it is, yes. This is a decision, X and another Hounslow Loughborough Council, 2009 PTSR 1158, a decision of Sir Anthony Clark, the late Sir Anthony Clark, Master of the Rolls as he then was. The part of the decision that I intend to take the court to is on page 352 of the bundle. To paragraph 60. And again, I would just invite the court to read paragraph 60.
yes,
What paragraph 60 does, in my respectful submission, is it closes the door on any need to go through the Caparo and Dickman three-stage process in cases of this nature where it's a claim against a local authority. Essentially, the courts have decided that unless a claimant can come within those categories where the common law recognises a duty, unless a claimant can come within those categories from Gorringe, there can be no further claim in common law negligence. And the words that I underline from paragraph 60 are only in such a case, i.e. in a case where the claimant can come within the Gorringe categories, would it be fair, just and reasonable to hold that the local authority, such as the council, on facts such as this, owed a duty of care to the claimants?
So where was that bit? I did see it a minute ago.
Where's my lord? It's paragraph 60, 5 lines down.
Yeah. But it really depends how you read it, doesn't it? If you read it as saying sorry, this is complicated. If you read it as saying that it's got to be a Phelps or it's got to be a Barrett or it's got to be causing damage, then there's no duty. Then you just shift the question to saying, can you squeeze your case into particular categories?
Yes.
I mean, in one sense, this has been refined and superseded in subsequent cases. But the question always is, when dealing with duties of care, do you have a set of circumstances where the law either does or by incremental steps ought to recognise the existence of a duty of care?
Yes.
I think what I'm getting at is you can't really take Gorringe or indeed X or indeed the cases that come after and just say that the categories are so closed that unless you're a Phelps or unless you're a Barrett, you can't have a duty of care. I mean, I understand your primary submission, which is the existence of a power does not of itself give rise to a duty of care.
Yeah.
Nor does the operation of it, however ineffectual it may be. I just slightly jib at something which appears to make it so hermetically sealed that you just can't go there again.
I suppose, well, the way that I look at it is that, and this is distilled in greater detail in subsequent cases, particularly Robinson, I'll come on to. But the categories are very clear, and as I'll submit in a moment, are quite clearly distilled. The area for movement is in what exactly those categories mean. A good example is this case, because the claimant is making a submission that, well, this defendant falls in the category of creating a danger such that a duty of care attached to the defendant because it issued licenses for the trading, because of its issuing licenses and regulating the market. The defendant puts that as high as saying that creates a danger. That requires us to look, as we will, at what exactly the law means when it says a defendant creates a danger such as to come under a duty.
Well, that picks up on what I asked you about earlier, about running the market in such a way as to create a danger and what that means.
Yes.
Okay, thank you.
With that, then, if I may go to Robinson at page Robinson of West Yorkshire, Chief Constable of West Yorkshire, 2018 appeal cases 736 at tab 17. Hopefully, by that stage, we're in volume 2 of the authority bundle.
Sorry, but I just can't.
It's tab 17, my lord, but I'm going to go. I'm going to go to page 472. To the judge of Lord Reed. I've highlighted in the margin paragraphs 32 down to 37.
Sorry, could you give me the page number again?
Apologies, my lady, it's 472. And it's a section of the judgment that's entitled with the subheading Public Authorities in General. I've highlighted a significant part of the passage from paragraph 32 to 37. I won't invite the court to read that all now. I'm sure it's a passage that the court is familiar with. It's a very helpful passage, if it's me to say that, because it really does tie all of this together and in succinct and coherent terms make the point about the circumstances in which a common law claim can arise where a defendant is discharging their statutory functions. The only part that I will take the court to in detail at the moment is paragraph 34 towards the bottom of page 472. I would invite the court to just read that paragraph, in particular, the extract from Tavares and Steele. What Lord Reed does here is endorse those categories that are helpfully distilled into Tavares and Steele. There are 4 of them, although I would add a 5th, which is the one that comes before number 1. In the tort of negligence, a person A is not under a duty to take care to prevent harm occurring to person B through a source of a danger not created by A, unless, and pausing there for a moment, that covers the positive act.
Yes.
Positive creation of a danger, which we will come to. What does that mean? But if it isn't a case of a positive act creating a danger, then the exceptions where the court will typically find a duty, including a duty to act, a duty that encompasses omissions, are 1, assumptions of responsibility, 2, doing something which prevents another from protecting B, referred to as, we'll see, the interference principle, very much at the heart of Tyndall, that came subsequently. 3, a special level of control over that source of danger. That's a reference to the principles we'll see from Dorset Yacht. And then finally 4, a status. Now, in this appeal, we can dispense with 2 and 4, but we're really concerned with assumption of responsibility, although, as I say, as I understand it, the claimant's position is that the judge wasn't really finding an assumption of responsibility in the classical sense. 3, which is the special level of control over the source of danger. And then the 3rd basis of liability in this case is, as I say, the positive act category, where the common law recognises a duty on anyone that creates a danger from a positive act. The law imposes on that person a duty of care.
But again, the highest that is put, as I understand it, is that the creation of a danger is by inaction.
Yes.
A failure to supervise or a failure to enforce.
Yes. Well, to come from a law's point, the basis upon which Malone Friend puts it in his skeleton is that the creation of the danger is issuing the licences to the traders to operate.
Well,
that's what it put. But it is. But I need to deal with it because that is what is being said in Malone Friend's skeleton, that the act that gives rise to this is licensing and regulating the market. That's the creation of danger. Of course, the reason it's put like that is because it's common ground that the defendant did not put those holes there, and so in a sense the claimant has to broaden it to that extent if they're to refer to the positive act. But I'll foreshadow my submissions because this is something that has come up. It has come up in subsequent cases. I think my Lord Justice Stewart dealt with it in the appellate decision in Tyndall. We have some cases like Robinson, which are a very clear example of a positive creation of danger, where the police arrest someone, tackling them on a street through which a vulnerable pedestrian is passing. That's a very clear example of a positive creation of danger. We have less clear examples, such as N and Hall.
Well, the Supreme Court in Tyndall said the way you approach it is to look at what would have happened if they'd done nothing.
Yes,
That's your baseline.
it is, but I suppose at a very fundamental level, the claimant's position, as I understand it, is that, well, if the defendant hadn't issued its licences, there'd be no street trading, and therefore this wouldn't exist. This is the difficulty. The difficulty arises because in most of the cases that we're concerned with, it is a case where the defendant has truly not done anything. So the police who's turning up to an accident scene, for example, they've not done anything to cause the black ice on the road.
I think you're slightly parodying the claimant's case, aren't you? It's not just you established this market, you issued licenses, therefore you're liable for anything that happens. It's the claimant's case is you established the market, you issued the licenses, you therefore came under a negligence duty, a duty of care not to run the market in such a way as to create a hazard, or a nuisance duty, ensure the market was managed and run in such a way that there was no public nuisance. I'm not saying that those are good claims, but I think it's taking a lot of shortcuts to say that the claimant is saying you ran the market, you issued the licenses, and that's it.
Perhaps if I take the court to where I'm getting this from, it back to the core bundle at page 55 is the letter on skeleton iron. Paragraph 4.3.
Yes.
What my learned friend has done is set out the law, and then says court below found the appellant to. Sorry,
Forgive me, what page are you on?
Sorry, my lord, on page 55 of the
My
court
mistake. I'm sorry.
paragraph 4.3.
Thank you.
The court will find reference there to the positive acts that are relied on.
Yes.
The positive acts are said to be licensing and regulating the market in circumstances where the defendant was aware that there were issues, long-standing issues in and around the market with traders abandoning equipment. Now, the second part of that goes to foreseeability, I suppose. But it is in my submission being suggested that the positive acts that carry the duty of care are the acts of licensing and regulating the market. But what I intend to do is take the court. In fact, I may do it now. To take the court to a case in which it's probably the most useful case that we have, in which there have been discussions in each of the judgments dealing with, well, what exactly do we mean when we say positive acts creating a danger? How broad is it? That is the decision in Mitchell and Glasgow City Council 2009 one appeal cases 874, which is at tab 10 of the authorities bundle. the reason why this case is helpful is because it's a case in which, to use the words Baroness Hale that I will come to, the authority in this case was an actor in the drama. It did positive things which foreseeably and factually caused deceased death. And there was an attempt in this case to argue that they had committed positive acts, the authority had committed positive acts, so as to give rise to a duty of care. It's probably helpful just to consider the facts, and they're relatively straightforward. This is a case where the deceased and his attacker, who murdered him, were both neighbours. They lived next door to each other. They were both tenants of the local authority, both secure tenants. And the attacker, the true cause of the deceased death, was also therefore a secure tenant of the local authority in the accommodation next door. And so in a sense, what the local authority had done in this case was issue tenancies to these two individuals, put them next door to each other, literally, but then had taken a number of steps, a number of positive steps towards dealing with this issue of antisocial behaviour, that went beyond antisocial behaviour, the issue of the conduct of the attacker to the deceased. The local authority well knew that the victim was at risk. There had been a long and tortuous history of attacks, arrests, local authority interventions, but matters came to a head when in July 2001 the local authority summoned the attacker to a meeting, essentially told him that they were going to recover possession. At that meeting, the attacker became very violent, and within an hour of the meeting having started, he had gone and killed his neighbour. And so this is a case where there was plainly proximity and there was plainly reasonable foreseeability. Those were not an issue. The question, one of the questions, was whether the local authority's actions carried the duty that the claimant in that case contended for, which was a duty to, essentially the claimant was saying, well, if you're going to summon this person who you know had a history of violence, who you've been trying to intervene with in the past, if you're going to summon him to a meeting at which you're going to tell him that you're recovering his flat, then you owed a duty to tell the deceased that you were going to do that. As I say, on a history where the local authority had done many such things in the past. And it was alleged in this case that the positive act of calling the attacker to that meeting in those circumstances gave rise to the duty to warn. Each of the decisions touches on this question of, well, what do we mean by a positive act? And I was going to just take the court to each of them. Some are in more detail than others. If I could begin with Lord Hope at page 312. Paragraph 23 at the top of page 312, Lord Hope gives an example of a creation of a danger situation by reference to Haynes and Harwood, where a van drawn by horses in a crowded street was left unattended. And so clearly there, if one's going to put horses in the middle of a crowded street and then leave them, that's creating a danger. In many ways, analogous to someone depositing poles on a highway. that's leaving a danger. So that's as far as Lord Hope takes us. Lord Scott goes.
And you're citing this as examples of positive acts.
Yes, that's the furthest I can go with Lord Hope, my lord. He gives there an example. His lordship gives an example of a positive act.
Thank you.
But in my submission, it's an example in the traditional understanding of creating a danger, where one installs or puts something that's dangerous in a crowded street. Lord Scott deals with this at page 318. At paragraph 40, and I would just invite the court to read the first half of paragraph 40.
Yes.
The words that I underline there are: if a defendant has played some causative part in the train of events that have led to the risk of injury, a duty may arise. There are further parts of Lord's speech decision that I will take the court to, but that sets out in general terms the broad proposition. Of course, that's not enough in itself, because simply playing a causative part in a chain of events cannot be creation of a danger. It has to be more than that. And that comes out from the remainder of the decision of Lord Scott. At paragraph 42 over leaf, I highlight that because Lord Scott summarises what the claimant in that case was saying the positive act was. It was the meeting that provoked the fatal assault. And at the bottom of paragraph 42, Lord Scott says, this to my mind is the critical question that arises on this appeal. Was this causative link enough to cast on the local authority a duty? And then at page 320, between C and D, I could just draw the court's eyes to that section of paragraph 44. Lord Scott held that the actions of the local authority on the 31st of July in giving Drummond a final warning about his conduct, that action cannot suffice to cast upon the local authority the duty. Lord Roger, in my submission, deals in the most helpful terms with this point and provides more reasoning and analysis. And I wonder if I could take the court please to page 322, paragraph number 55. And I would, if I may, just invite the court to read paragraph 45 in full.
45.
Sorry, I think
Oh, you said 55, but
Yes, paragraph 55 on page 322 over onto page 323.
yes. Yes, well, that puts the question. Do you want us to go on beyond 55? It goes on to Smith and Littlewoods and so on.
Well, in my submission, what paragraph 55 is doing is making the point, a principle that is well known to common lawyers, that it takes more for a positive act to carry a duty than simply the act giving the occasion or the opportunity. These are my words, but in my submission, what Lord Roger is doing here is saying if the positive act has to be a proximate cause of the danger. Lord Roger, at paragraph 57, at the bottom of page 323, and I would, two quite long paragraphs, but I would just invite the court to read paragraph 57 through to 58.
Yes.
So what Lord Roger is doing, in my respectful position at paragraph 57, is giving examples of where the law traditionally recognises a duty for creating a situation of danger. And the common theme through all of those examples is that they are, as I called it, proximate examples of where the act is proximate to the danger. And then at paragraph 58, Lord Roger makes the point that, well, in this case, all that Glasgow City Council was doing was performing its statutory function. It wasn't doing anything wrongful, and notwithstanding that it plainly knew that its actions could have provoked the results that unfortunately transpired in that case, that was not a positive act that could give rise to the duty based on a creation of a dangerous situation. Baroness Hale, at page 329.
It's not your fault, Mr. Hedgeman, but this case seems to me a good illustration of why the Supreme Court are right not to follow the old habit of the House of Lords of all five of them giving speeches saying slightly different things. We had to spend half an hour trawling through it to see what the ratio of the case is.
Yes, I appreciate that, my lord. I think Baroness Hale is the last extract that I will take.
Paragraph 76.
Paragraph 76,
Yes.
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 These are the words that I foreshadowed earlier, and Baroness Hale there, recognising that in this case the local authorities were an actor in the drama, and worse than that, they were an actor who knew that their actions could have the consequences that they did. But the point again being that didn't create a duty. Those positive actions didn't carry a duty. The point came up again in N and Paul, which the court will find at tab 18 of the bundle. 2020 appeal case 780. And a similar type of setup, in that in that case what the local authority had done had moved children and their mother into a property next door to a family that it knew was abusive. And the claim was essentially for abuse inflicted by that family. And the claimant did argue in that case that this was a positive creation of a danger. And Lord Reed dispensed with that at page 563. And I would just invite the court to consider paragraph 76, but only to the extent to note that those categories of common law liability, or potential common law liability, are set out, as we've seen from the case of Robinson. But then paragraph 77, Lord Reed deals with the suggestion made by the claimant that the duty arose because of the dangerous situation that the local authority had created by placing the claimant next door to the abusive family.
So was it, in Mitchell, was it determinative that in general terms a landlord doesn't owe duty of care in relation to their tenants' antisocial behaviour?
I don't believe it was, my lord. It was certainly that was the context. That was the context, and the court accepted that, of course, there were duties. There were extant duties that the housing association owed to the deceased tenant. But there was no suggestion, and of course neither could they be, that those duties extended to a duty to warn from foreseeable actions that could cause harm to a tenant. But what the claimant was trying to do in Mitchell was bring about that extension. And in my submission, certainly a pillar of the reasoning as to why that extension was not permitted was because, well, two things. First of all, that the act was not a proximate cause of the creation of the danger. The acts alleged were not a proximate cause of the creation of the danger. And secondly, that all Glasgow was doing was performing acts as a diligent local authority should in performing their statutory functions. So it couldn't be said to be wrongful. Unlike a situation where someone deposits something dangerous on a highway, which is plainly wrong. I think that's everything I intended to say on this first limb of liability about creation of danger. I have put in the bundle some authorities that make the obvious point that creating a danger or a nuisance on the highway carries a duty when that's what someone does, but I'm not going to take the talk for those. I'm sure it's not familiar with that principle. I would just at this juncture pause to note that my learned friend, in support of his submissions that this defendant created a danger, relied at trial and before this court on a decision of Mr. Justice J in the High Court, Suffolk County Council and Lisle at tab 22. I'm not going to invite the court to turn that up now. There's no doubt my learned friend will address it, but it's a straightforward case. It's a classic case of creating a danger on a highway. It's where the local authority installed onto a highway boardwalk that was liable to become slippery. So it's just a straightforward application of creating a danger on the highway. In my submission, that authority, such as it is, can't support the extent of duty that's been contended for on these facts. That then takes me to the second limb of liability in this case, which is the concept of control. I'm going to take the court to two cases, Home Office and Dorset, and then Tyndall on this. That the essential submission is going to be that where the courts have identified a relationship under which the defendant has control of the tortfeasor, the extent of the control has to be significant. And therefore, in this case, all that can be said of this defendant is it had regulatory control conferred by Parliament. And my respectful submission is going to be that gets nowhere near the threshold at which control should be taken into account as sufficient to establish a private duty. With that said, if I could go to tab 3, please, of the authority bundle to the case of Dorset. Home Office and Dorset Yacht Company, 1970, appeal cases 1004. sure the facts are well familiar to the court. This is a case where the Borstal boys were taken to Brownsea Island in circumstances where they were under the custody and control of the officers who took them there.
They were in custody.
They were in custody, yes. Yes, and the officers had clear instructions from the Home Office to keep them in custody. Regretfully, the officers fell asleep when, in plainly foreseeable circumstances, the Borstal boys tried to make good an escape up into the sea they went, where the claimant's boat was, and it was damaged. I should say that Home Office of Dorset Yacht has been looked at through different lenses in more recent authorities, and to that extent it may not be necessary for me to go through Home Office and Dorset Yacht in any detail, and perhaps be more useful to go to Tyndall, which I will do in a moment. But it has been analysed as a decision based on vicarious liability for the officers, the 3 officers that took the Borstal boys to Brownsea Island, based on the Home Office's vicarious liability for them. It has been based on a duty that arises from the extent of the control that those officers had, particularly their instructions to keep the boys in custody and under control, the officers being their custodians. But then it has, and this is really through the lens of Gorringe and more recently Robinson, it has been also looked at as a creation of a danger situation. Because it might well be said that where one takes individuals who are in one's custody to an island where they are going to try and escape, and those individuals are dangerous, that really is a proximate cause of creating the dangerous situation that unfolded. I don't know, would it assist the court to look at the various passages in Dorset Yacht about making the point that custody and control was the crucial factor, or shall I simply move to Tyndall?
I doubt it. You can come back to it if it ever becomes necessary. But Tyndall is very recent. And,
yes, I'm grateful, my lord, for that indication. In which case, I shall turn, if I may, to tab 21 in the authority bundle, which is Tyndall and Chief Constable of Thames Valley Police, 2025 appeal case 1046. The appropriate part of the joint judgment of Lord Legate and Lord Burrows is at the bottom of page 633, paragraph 78, conveniently under the heading Control. At paragraph 78 and 79, the Supreme Court sets out the Dorset Yacht case. And at paragraph 79 on page 634, makes the point that I just did, that sometimes Dorset Yacht has been analysed through the prism of it's a creation of a danger case rather than a control case, but the two points worked in conjunction. At paragraph 80, the Supreme Court explores the reasoning in that case, in Dorset Yacht, and refers to a decision in Carmarthenshire County Council and Lewis, 1995 appeal cases 549, with the analogous situation of a parent or a school who is in custody of custody is not the right word to use, but is clearly in control of the children in their school, such that where a child escaped the school and caused a road traffic accident, that was a loss of control caused by the school. Perhaps the more important point for our purposes comes out of paragraphs 81 and 82. There, the claimant in Tyndall was trying to broaden the concept of control to encapsulate the actions of the police, in this case, turning up to an accident scene and exercising some control over the accident scene. And so I would just invite the court to read paragraphs 81 and 82.
Yes.
So paragraph 81, the court will see that what the claimant was trying to do was extend those principles from Dorset Yacht to, and this is the third line down of paragraph 81, any situation where the defendant has control over a particular source of danger, whether it be a human being or an artificial or natural hazard. Now, pausing there for a moment, that's a surprisingly broad proposition. And as the court went on to identify, one without any apparent clear authority. But even there, it seems the claimant was suggesting that there had to be a significant level of control if it's over a human being. And in this case, of course, the point that I make is on no commonsensical view can it be said that the defendant local authority was in control of the market traders. It had indirect powers to enforce against them, to subject them to sanctions, but it had no powers at all to control what they did, where they were, and how they did it. As it happens, the Supreme Court didn't need to resolve the question about whether the claimant's extension was correct, on a somewhat technical point that, well, the most it could be said was that the police had come to the scene of the accident and taken control of the scene at the accident spot, whereas the danger on the highway was, I think from memory, 50 to 100 yards away, and they've not done anything there.
Rather more than that, so I think somewhere 184 metres is mentioned, but anyway, not the same location.
Yeah. So the police didn't do anything around the black ice, they only took care of the accident scene. So that was the reason why the Supreme Court didn't deal with the proposition, albeit, I think I can say this, that the Supreme Court seriously doubted whether the claimant's proposition could be correct. Paragraph 82 saying there's no clear authority to support it, and then paragraph 82 also saying it would be a significant step to extrapolate from this to a danger occurring on land to which all members of the public have a right of access. So if by analogy this was a case where the defendant, the local authority, had found these poles as they were abandoned on the highway and had attempted to set up some kind of warning or cordon around them and then removed the warning or cordon, then maybe that would come within the scope of the principle contended for in Tyndall. But in my respectful submission, there is simply no authority to support the position that the control authorities, if I can put them like that, would support the conclusion that this defendant owed the users of the highway at large a duty arising from their regulatory control of the market. Can I assist the court any further on that point?
Where have we got to? You've covered creation of danger. You've covered control.
Next up is assumption of responsibility, but I don't intend to be any more than about 3 or 4 minutes on that.
Go ahead then.
And then that will just leave the public nuisance issue.
Yes.
But the reason I don't intend to say very much about assumption of responsibility is because although the judge below clearly took into account the authorities on assumption of responsibility, particularly Phelps, and particularly Barrett, as I understand my learned friend's submission, it is accepted that the basis upon which liability was found was really on these issues of creation of danger and control, not assumption of responsibility as such. The reason for that position is obvious, because while we're in Tyndall, if I would just take the court back, please, to page 633. To paragraph 76. Their lordships make there the point that the basic stumbling block for any argument based on assumption of responsibility in this case is the complete absence of any communication or interaction between the officers and Mr. Tyndall, who was using the highway. So assumption of responsibility, as it is now understood, although it has in the past been used in vague and sometimes unwieldy terms, our understanding of it now is really quite straightforward. The cases make that clear. Taking a child into care is clearly taking that particular child, quite apart from the statutory function to do so, taking that particular child into care is clearly assuming a responsibility for them. Similarly, having a child assessed for psychological issues by a professional in circumstances where it's known to everyone that that advice is going to be relied on is exactly an assumption of responsibility that any professional has to their client, in that case a medical practitioner. What one can't do is extend assumption of responsibility to a situation where, in truth, the position between the parties that are said to be in this relationship of responsibility are total strangers. And that's the point made at paragraph 76 of Tyndall. And that point has to, in my respectful submission, apply in this case, because the claimant and the local authority, Tower Hamlets, were strangers to each other. There was no communication at all between them. So it's totally the opposite end of the spectrum to the type of cases where an assumption of responsibility arises. But as I said, the claimant submissions to this court are really inviting the court to consider the control issues and the creation of danger issues rather than notions of assumption of responsibility, to the extent that the judge was taking those assumption points into account. That then leaves the last of my substantive points on the first ground of appeal, which are the nuisance points, so I can group them like that for the time being. Appreciate we're just gone 1:45 now. This may be a convenient moment.
We could break off now. You could take the opportunity to look at the Woodcock case as it follows on from Tyndall. You may not want to say much about it except that you agree with it, but we'll see. We'll resume then at 1:45.
Court rise in favour.